Hi, I'm Nicole Hemrick, the founder and managing partner at Hemrick O'Malley, PLLC. Today, I want to talk to you about a big update from USCIS that affects many families waiting for their green cards under the Child Status Protection Act, otherwise called by its acronym CSPA. The CSPA was created to help protect children from aging out, meaning turning 21 before their green card is approved in certain family-based, employment-based, or diversity visa category cases. Under normal immigration rules, if a child turns 21 before getting his or her green card, he or she is no longer considered a child for immigration purposes and can lose eligibility. The CSPA provides a special formula to freeze or lock in the child's immigration age so he or she may still qualify. One key part of that calculation is deciding when a visa becomes available. For many years, that was based on the final action date chart in the Department of State's Visa Bulletin. But in 2015, the Visa Bulletin started showing two charts, dates for filing and final action dates. And for a while, USCIS only used the final action dates chart. Now, I am going to share my screen to show you what we're talking about here. Here we go. So this is the URL. If you were to just Google Visa Bulletin, this will come up and you will see here final action dates and filing dates. And you'll see that on family, employment, diversity. So based on what type of immigrant visa application it is, there are different charts, but there are different dates for both. In February of 2023, USCIS made a big change. When they would allow people to file early under the dates for filing chart, they also used that earlier date for the calculation of the CSPA age. That meant more kids could qualify because their frozen age was calculated sooner. Here's the problem. The Department of State never changed its rule for people applying for visas abroad. The Department of State always used the final action dates chart. So kids applying inside the U.S. and applying outside the U.S. were treated differently. To fix this inconsistency, USCIS is now going back to using only the final action dates chart for everyone, whether you're applying inside the US or abroad. This creates uniformity, but it also means that fewer people may qualify under the CSPA going forward. Here's what you need to know. This new rule takes effect on August 15th, 2025. If your adjustment of status application is already pending before that date, USCIS will still use the old February 2023 rule for you. There's also an exception for extraordinary circumstances. If you can show a very good reason why you didn't apply earlier during the old policy window and your delay was reasonable, USCIS may still use the earlier dates for filing chart for your case. So, bottom line, after August 15th, 2025, CSPA age will be calculated based on the final action dates chart only. If you have a pending application now, the old rule might still protect you. If you have questions about this update or any other immigration matter, give us a call at 833-848-7838 or visit us online at www.hemrick.law. And as always, stay hopeful.